Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5290, Robert Schilling, States House of Representatives, et al. Mr. Hardy for the appellant, Mr. Craig Nile for the appellees.
Morning, Mr. Harden.
Good morning. This is my first trip to this court in my career, so it's a good morning for me.
Welcome.
Well, thank you. May it please the court. This is a case that comes to this court on a very sparse record. It's a case about whether the American people, under the United States Constitution and the common law right of access, have the right to seek documents not just from this branch of government. It's well established that judicial records are subject to common law right of access, but also from the legislative branch. We would submit that in a case of this type, at the very least, we need a much more fulsome record. The case was dismissed on speech or debate immunity. There's a very lengthy opinion from the district court on that issue of speech or debate immunity, and then this court issued an order with the briefing schedule that said that the parties should also address immunity as it applies to the committee as opposed to just members of Congress. And so I'm going to address the government's arguments on each of these points since they were the prevailing party below, and then I'll explain why Mr. Schilling believes the government is in error. The first, of course, is speech or debate immunity. That is what the district court ruled based upon. But I think that there is an important new case from this court. In fact, it's so new, it was uploaded to Lexis while I was preparing for oral argument, and that is In Re Sealed Case 80 F 4th at 355. It was handed down on September 13th, but as I said, it was not uploaded until quite recently. In that case, the argument was involving access to Representative Scott Perry's cell phone records and communications. And in that case, Representative Perry argued that he was engaged in legislative acts and he was entitled to speech or debate immunity because he was engaged in informal fact-finding relating to the 2020 election. He was presumably texting and calling people to ascertain facts on the ground. This court said in that published decision just a few months ago that investigative activity is much more narrowly defined. It's not informal fact-finding. It's not communications with outsiders. Investigative activity is things that Congress does as a whole. And so this court rejected Scott Perry's arguments. This court sent it back to the district court and said that we needed to go through Scott Perry's text messages, communication by communication or line by line, to see what communications might be legislative acts and covered by speech or debate immunity and what communications are not.
Just so that we're clear, is the House, is the Oversight Committee within the realm of senators and representatives under the speech and debate law?
Our position is that it is not. Our position, first, just to preserve it, is that we think that the existing case law has already stretched the Constitution to its breaking point because the Constitution says senators and representatives. Of course, if we accept the precedent that we admit exists that has stretched the Constitution, then we go into, are these staff people are entitled to immunity when they are doing things for which their employer would be entitled to immunity. That's the crux of the argument. Here, I would argue that these are not staff and they're not doing things that are subject to the jurisdiction of their employer. A committee is a diffuse group of individuals, and it has I guess, staff that serve different interests, not one sole interest. And I think that we're getting further and further from the constitutional text instead of closer and closer when we stretch speech or debate immunity quite that far.
Is the basis of your cause of action 28 USC 1361?
I think that we've
Mandamus action.
that is one basis, is the short answer. I think that we also invoked declaratory judgment, and we also believe that this is just a constitutional provision that is itself self-executing.
So declaratory judgment actions are not, that's not a cause of action. You have to have a cause of action that's valid. And then the Declaratory Judgment Act gives you relief, but under whatever that cause of action is, but the Declaratory Judgment Act itself doesn't establish a cause of action.
And I think that the common law right of access is a cause of action that grants us relief, as is evident in a series of cases, including Washington Legal Foundation versus Sentencing Commission, which we invoked.
Washington Legal Foundation was a mandamus case. It was a 1361 case. It's not like you can just file a complaint and say common law right of access, and that's our cause of action. It has to be grounded in a federal statute that creates, I mean, you can't just cite a case and say, we have, Fifth Amendment due process right or a First Amendment free speech right. You have to cite,
Sure.
Section 1983 or something that is a basis of your private right of action. So other than 1361, is there something else?
I think that what I get out of Washington Legal Foundation is that there is a mandamus cause of action if you're right on the merits. And so the mandamus factors sort of merge with the merits. And if there is such a thing as the common law right of access, then it is enforceable through mandamus.
So you're basically arguing that you have a federal claim and that under the Larson-Dugan exception, you can enforce common law right of access against the House. Right?
Yes, Your Honor, that is.
I mean, there is not in our circuit or from the Supreme Court, there is precedent that 1361, which you cite in your complaint, is actually available only to officers or agencies of the United States, and it's been limited to the executive branch. As I said, we have not so held, but that has been the unbroken line of authority in other circuits. So I think I take it you're resting on 1331 and then arguing that Larson-Dugan is your route around sovereign immunity and to enforce the common law right of access. Is that correct?
I think that's correct. Again, they've argued three things. They argued speech and debate immunity, sovereign immunity, and then that the common law right of access doesn't apply or in some sense. And so our argument on sovereign immunity is you are correct that we're arguing Larson-Dugan.
And I think you alluded to this, the analysis then sort of merges with the merits of the common law right of access claim, and focusing on that, are these public records what you're seeking?
So at a bare minimum, what I get out of In re sealed case that was recently handed down is that's a fact-intensive inquiry, whether there's a legislative act being taken, whether it's public records, everything is fact-intensive and it needs to go back for analysis of each record. Now, I would submit that one of the other things that's in that case, In re sealed case, is this distinction between a legislative act and an official act. And so there is a possibility that something can be a public record generated in your official capacity as a congressman or a member of a committee or a staff person to a committee, and it would not necessarily be legislative. Again, the proper thing to do, I think, and what this court did in that case is remand for substantive analysis. And I think that's really our request here. We're arguing all of these issues in the dark because the Congress never even answered, the Congress never even answered whether these records existed. The pleadings are replete with, if they exist, the records are not public records.
But why wouldn't we, as we ordinarily would do when the case is at the pleading stage, look at the characterization of the documents in your complaint and see whether that suffices to answer the question whether the requested records were created and kept for the purpose of memorializing or recording an official action, decision, statement, or other matter of legal significance. And if they're not, and as I read the complaint, they aren't, then we would dismiss on that ground.
I think you're correct that the court can look at the complaint and its allegations. I think that our allegations are that these are individuals communicating with a committee, and the district court says it's, facially within the committee's jurisdiction. I wouldn't say that we conceded that, but that was the district court's characterization. And so if we have individuals corresponding with a committee and it is facially in the jurisdiction of the committee, as the district court says, it's hard for me to see how that is not a committee action or a legislative action. And I think that, of course, the complaint has to be construed broadly in favor of the plaintiff at this stage too.
How does sovereign immunity apply here?
Essentially, if they're acting outside the scope of their authority, they are not entitled to sovereign immunity under the Larson-Dugan exception. And so we're arguing that these folks were acting outside the jurisdiction of the committee, outside the rules of Congress, and so they're not entitled to that. I think it merges into the merits, and that's why I think the proper thing to do is remand to
You're
address
not
it.
disputing that these defendants, even though they're not executive agencies or officials, they're members of the legislative branch, there's no dispute in your mind that they're presumptively entitled to sovereign immunity unless and until there's a route.
I agree with that, Your Honor. And I think that our argument is that they have, through their actions, met the exception under Larson-Dugan. And I believe my time has expired, and I will reserve for rebuttal. Thank you.
Morning, Mr. Craigmom.
Good morning, Your Honor, and may it please the court. I think that I will just jump right into some of the discussion that was just going on, and I'll start with a response to In Re sealed case. So that case is very different from the case we have here. In Re sealed case, of course, dealt with a personal cell phone, and there was a mix of legislative and non-legislative acts. And Mr. Perry made an argument there that equated official acts with legislative acts. Under his argument, certain communications that involved press releases and newsletters, those would have been under the definition of legislative act. The court said in Re sealed case, that's not consistent with this court's precedent. Legislative acts are not the same as official acts. Here, however, we're dealing squarely with a committee investigation, a committee legislative oversight investigation. And the communications being sought are those between committee members, committee staff, and third parties who, according to the complaint, performed services of the type generally performed by committee staff. In particular, on page 5 of the joint appendix, it says here we're talking about professional staff, third parties, though, planning investigative hearings. Paragraph 66 calls the third parties de facto staff. Paragraph 97C concedes that these materials would have been generated during the congressional oversight process. So we're not dealing with a mix of legislative and non-legislative acts. We are squarely dealing with legislative acts, and those are absolutely protected by the speech or debate clause.
You may have legislative acts protected, but what about case law directly stating that the congressional committees are entitled to the speech and debate immunity?
Yes, Your Honor. I do believe that this court and the Supreme Court, when it talks about and analyzes speech or debate clause immunity, it treats Congress, its committees, and its members consistently, identically. And that makes sense. Doing so accurately reflects the way that members discharge their duties, just as members rely on staff, who the Supreme Court has said are the members' alter egos and are also entitled to speech or debate clause immunity. They also rely on congressional committees to perform their official duties. And writing a rule where a plaintiff could simply plead around this absolute immunity by naming a committee or naming a a chamber of Congress would really create an exception that would swallow the entire immunity. And that's inconsistent with what the Supreme Court and this court have said about how the clause should be interpreted, which is broadly to effectuate its purposes.
Does sovereign immunity apply here?
Sovereign immunity does apply, Your Honor. In our view, speech or debate clause immunity should be the beginning and the end of this case. Alternatively, all parties are entitled to sovereign immunity. There was some discussion earlier about Larson-Dugan. Larson-Dugan is triggered only if there's an allegation that the official acted beyond his or her statutory authority.
Well, in this particular case, it looks like the complaint says documents will show evidence of wrongdoing. And of course, they're arguing that they never got that far, you know, in terms of actually receiving the documents or the documents revealing themselves. So we only have a will show allegation. Does that affect your analysis?
Not at all. Even if we assume those underlying documents show unlawful behavior, that's irrelevant to the Larson-Dugan analysis here. Here, we're relying on a common law right of access. So the complaint alleges that the House unlawfully denied the common law right of access. The alleged violation here is a common law right of access. And a common law, by definition, cannot trigger Larson-Dugan, which relies on a statutory violation or an alleged constitutional violation. And speaking of sovereign immunity, Washington Legal Foundation was discussed earlier, and Judge Pillard mentioned, or maybe it was Judge Wilkins, that relied on mandamus, and mandamus does not apply to Congress. So there's really no way to run the common law duty through any sort of statute. That point was not disputed in the reply brief. So sovereign immunity, Your Honor, would be an alternative ground, but we really think that speech or debate clause immunity fully disposes of this case.
But we do have cases suggesting that the common law right of access supports a claim or circumvents sovereign immunity under Larson-Dugan. I know your position is reading Larson that it only applies to a statutory or constitutional claim, but we have circuit precedents to the contrary, don't we?
Well, I believe that's only Washington Legal Foundation, Your Honor, and that was a mandamus action. And here, mandamus is unavailable because mandamus does not apply to Congress.
Why? I mean, there's jurisdiction under 1331 here, or assume there is jurisdiction for injunctive relief under 1331. Is your response the same? I'm not sure I'm getting your connection between.
As we read Washington Legal Foundation, it stands for the proposition that a plaintiff may bring a mandamus action to compel a government official to perform a duty, and that duty flowed through a statute. In that case, that was the mandamus statute. And so that's how you get through Larson-Dugan. One way to get to Larson-Dugan is through an alleged statutory violation. But here we don't have that because the mandamus statute does not apply to the House. And as I mentioned earlier, any alleged violation of these other statutes are irrelevant because the relief here is based on an alleged common law violation. But again, the court wouldn't need to go there if it agrees with us on speech or debate clause immunity, which again is an absolute immunity. And just to go briefly back to In re sealed case, that's another fundamental difference between that case and this case. That was dealing with an evidentiary immunity. Here, we're dealing with an absolute immunity from suit. And one of the purposes of that absolute immunity is to prevent the House from being subjected to the burdens of defending.
Why is this not more on the evidentiary side? Because the cause of action is not predicated on legislative conduct. This is not. It's not that the liability is predicated on legislative conduct, is it? It's that, the denial of records is the wrong. So it's predicated on the common law right of access.
Right, but we're still in absolute immunity land, Your Honor, because they've sued the House, they've sued a committee, they've sued a member, they've sued House employees, and they're trying to hold these folks in to defend themselves in litigation. And that's a core purpose of the speech or debate clause immunity, which is not only meant to protect the House from the outcome of litigation.
Can you speak to whether the documents are public records?
Yes, Your Honor. I think that Your Honor put her finger on it earlier. We're looking at whether the complaint plausibly alleges that these materials would be public records. And the complaint, I think, makes quite clear that we're dealing with preliminary materials, communications between committee staff, committee members, and third parties as they are executing an investigation. And there's no allegation that these were created or kept for the purpose of memorializing an official action or an official decision. We're dealing with preliminary materials that at best would have been relied on by a decision maker to then make an official decision.
Can you speak to the argument that there is jurisdiction under 1331 because there's a federal question somewhere, either the common law right of access or a federal statute? Because my understanding is that you still have to have some sort of a kind of basis for the right to bring the action. And that 1331 doesn't do that. You can't just cite a federal statute in section 1331 and have a claim.
That's consistent with my understanding, Your Honor. We haven't made an argument based on sort of a lack of cause of action here. As we read the complaint, one of the bases for a cause of action was the mandamus statute.
Well, what I'm trying to get at is a mandamus statute has very specific, you have to show a clear and indisputable right to relief and a clear duty to act and all of that. And so I'm trying to figure out does this case have to be decided within that framework, or is there some other framework available to the plaintiff where they don't have to meet that high burden, that high standard?
Well, I think if they did ever get to the merits, Your Honor, and were truly relying on a mandamus action on the merits, they would need to make that showing in order to be entitled to mandamus relief. I don't think that's the framework the court needs to use to decide.
I understand you think we can just decide this on speech or debate clause, but let's assume we disagree with that. But what I'm trying to figure out then is the only way to, if we get to the merits at all, is the only way to get that through the mandamus framework, or is the appellant correct that there's a different framework that's not as stringent that would apply to this claim?
I'm sorry, a different framework. That's what, Your Honor?
That would apply to this claim other than the mandamus framework if we got to anything touching them.
I'd maybe want to think a bit more about that, Your Honor. We didn't get into that in the briefing. As I read the complaint, it is arguing, or it is relying on the mandamus statute. And so it seemed, my first reaction is that all roads would lead back to the mandamus standard. But I'd maybe want to think a bit more about that.
And wouldn't it be the case that even if jurisdiction were premised on 1331, this would be in the nature of a kind of a mandamus action? I think, is it our decision in Fields? We've talked about the relationship between a 1331 based claim for an affirmative injunction against the government. And I believe it does somewhat assimilate the mandamus elements, the high standard.
Yeah, that sounds right to me, Your Honor.
So putting aside again, speech or debate for a moment, if we were inclined to affirm on the ground of sovereign immunity, obviously this is just hypothetical. We've not spoken, we've not conferenced. But on your position that you couldn't bring a Larson-Dugan action to enforce a common law right of action, I'm not sure theoretically that I really follow why that would be so. And I know the language you're relying on in Larson, but for example, under Ex parte Young, which is the analog for suing for injunctive relief against state officers, there's no such restriction. And I'm just wondering why there would be in the federal context. And if there is, then is there no claim at all for this kind of thing?
Well, I think the restrictions, Your Honor, come from Larson and Dugan themselves, which say that there's an exception to sovereign immunity only when we're dealing with an allegation that a government official has done something beyond his or her statutory authority or acted in a way that's unconstitutionally. And Larson itself said, even if there's an allegation that there's some unlawful behavior under sort of general tort law, that's not enough. It's got to be beyond statutory duty, and it has to be unconstitutionally. And so I think that's where the restriction comes from. But here we're just dealing with an alleged common law violation.
But it's a particular kind of common law. It's not tort law. It's not state law. It's a federal common law right of action. And one wonders how it would be enforceable if not under Larson-Dugan.
Well, I think that's our fundamental position, is that it's not enforceable against the House, Your Honor, for several reasons. There is no waiver of sovereign immunity. And then if we actually get to the merits, the common law right of access doesn't apply at all to Congress.
And pre-FOIA, pre-APA, there would be no common law right of access claim against the executive branch either, or against the courts under your theory.
No, I think that our argument applies solely to Congress, and that's because Congress has exclusive authority under the Constitution, the rulemaking and journal clauses to control access to its materials. This court's recognized that authority in its Goland decision.
Isn't that a different argument? That's an argument that there might be something displacing the common law right of access that would be a rule under the rulemaking clause, but not that the common law right of access just wouldn't apply.
I think it's the same argument, Your Honor. The argument is that if the common law would have applied to Congress, it no longer does after the Constitution gave both chambers exclusive authority to control its own materials. And again, I'll just read briefly from the Goland decision, which says that Congress has undoubted authority to keep its records secret, authority rooted in the Constitution, longstanding practice and current congressional rules. It's hard for me to square that. And I think it's relevant that Mr. Schilling hasn't pointed to any judicial decision that's applied the common law right of access to Congress, nor is there any decision applying the mandamus statute to Congress.
But are we ready to kind of do that line drawing here to actually say there would never be jurisdiction under common law right of access?
Well, if you're with us on speech or debate cause immunity, you wouldn't have to, Your Honor. The holding would just be, we're dealing with legislative acts. There's an absolute immunity. There's no balancing that's inconsistent with the fundamental nature of an absolute immunity. It's inconsistent with this court's precedent that says speech or debate clause immunity is jurisdictional. There would be no line drawing issues there. There also wouldn't necessarily need to be line drawing issues if you ruled alternatively on sovereign immunity. You could just say that Washington Legal Foundation is distinguishable because the mandamus statute doesn't apply to Congress. There's no waiver.
Or say these aren't public records. That the merits of the common law right of access fold into the threshold sovereign immunity analysis. And if one were to hold that there is no clear right, then done.
So we disagree that they would fold into each other, Your Honor, but to the extent that that's
Because you disagree that the common law right of access is even enforceable.
for a couple of reasons. I guess the fundamental reason is because we disagree that there's a way to get to Larson-Dugan under this court's precedent, under the Supreme Court's decision in Larson and Dugan. And if you can't get into an exception, then sovereign immunity applies, and you don't have to reach the question whether the common law right of access does apply to Congress. But to the extent that the court does fold in the merits into the sovereign immunity analysis, then the first question would be whether the common law right applies to Congress. It does not. We're unaware of any example, any court decision anywhere that's ever applied the common law right, or rather any decision from this court or the Supreme Court
Doesn't the
applying.
Center for National Security so treat the common law right of access?
Center for National Security, as I remember, Your Honor, said that this court has held that that the common law right applies to all three branches. It cited Washington Legal Foundation for that proposition. Washington Legal Foundation did not involve the legislative branch. That involved an entity within the judicial branch. So that was dicta. So although Center for National Security Studies said that respectfully, it was dicta in Washington Legal Foundation and it was dicta in Center for National Security Studies. But even if the court concluded that it was bound and even by that statement, and even if by getting to the merits, it felt that it needed to square that, the way to do that would be to apply the common law right to other entities within the legislative branch, not Congress itself, because those entities do not have this exclusive authority that this court recognized in Goland to control access to its materials. I see that I'm well over my time, but I'm happy to answer other questions.
Thank you.
Great.
Did Mr. Harden have time? We managed to ask you enough questions to use up your time, but we'll give you the rebuttal that you sought.
Well, thank you, Your Honor. I want to go back to In re sealed case on speech or debate immunity, because that's what the basis of the district court's opinion was and the chief argument on appeal. At the very end of that case, in the holding, they talked about documents that were not covered by speech or debate immunity. And examples of that were communications with private individuals, quote, about upcoming events, political talking points, articles of interest, etc. These were, quote, political matters not covered by the privilege. And so when they say these are documents with private individuals planning for committee hearings, that sounds like exactly what this court held in re sealed case, and in re sealed case was not covered by the privilege. And so I don't think that there's any way to square this argument that they're making on speech or debate immunity with that case.
But you concede legislating with regarding climate change is like within this committee's jurisdiction, right?
I think that's indisputable, that legislating on climate change is within their jurisdiction.
And you plead that the communications that you seek are communications addressing that topic, right?
I don't think we plead that they're communications addressing legislating on climate change, Your Honor. I think we plead that they are communications by people seeking an outcome. I think that outcome includes things like referrals to DOJ and our complaint. And so it's individuals seeking things out of the committee, but I definitely don't think that we're saying that these individuals are seeking legislation out of the committee. And so again, I think that this court has been clear that the common law right of access.
But even if it was relating to a referral, isn't the committee, isn't it within the committee's jurisdiction to refer someone or something or some issue for investigation or consideration by the DOJ?
Well, I believe it's a little deeper than that in the complaint. We call it, quote, engineering a referral. And I think that the allegation is that this is misuse of the committee and misuse of the referral process, since that gets back, I guess, to Larson-Dugan immunity. My time is very close to expiring, if not expired. I will conclude by saying that the district court held in the Schwartz case in 1977 that the common law right of access applies to Congress. This court held in national security studies that it applies to Congress. There is no right without a remedy, and it would be an extremely anomalous result to find in this case that there is a common law right of access, but that it is unenforceable against one branch of government. Thank you.
Thank you. The case is submitted.
Case number 22-5252, Shawn Musgrave appellants versus Mark Warner, Chairman, and Senate Select Committee on Intelligence. Mr. McClanahan for the appellant, Mr. Valero for the appellees, the Polham amicus curiae.
Morning, Your Honors. My name is Kelvin McClanahan. I'm here on behalf of Shawn Musgrave, the appellant in this case. And most of the questions that you would have to resolve in this case were addressed in the previous case. And so we can sort of skip straight to the sticky questions that are unique to this case that separate it from everything else. Mr. Musgrave does not dispute that privilege is absolute when it applies. We dispute that it does not apply and that the district court's reliance on the previous statement that committee reports are protected necessarily implied in that case or where appropriate, and that not all committee reports are protected, just like not all fact-finding is protected, as this court held in re sealed case discussed before. This report has a unique pedigree where when it was ordered to be compiled, it was ordered to be compiled for dissemination, for being presented to the government.
I mean, you pointed to things in the record that support that purpose, but it seems quite counterintuitive to infer that there was some exclusive purpose. I mean, the notion was this was going to become a touchstone for all kinds of reform efforts throughout government, presumably including legislative efforts. I mean, that is what congressional investigation principally is about. Plus, something can be a report, an investigation can be undertaken with the purpose of informing a decision not to legislate. So I think you're maybe placing more on the purpose to inform and help perhaps educate CIA actors than it can bear.
And that is a well-taken point. I think that the distinction here and why this is an edge case is that not only was the stated intention to be for the benefit of the executive branch and for the public, but the actions were for the benefit of the executive branch, that when it was completed, it was immediately sent to the executive branch. It was not held for deliberations, and the quotes, as you pointed out, were even from Senator Burr, who tried to claw it back, said that the study does not offer any recommendations. And I think that the key part here is that Gravel and Doe and Hutchinson all talk about the deliberate nature of the records, the purpose for the deliberative process, and making speech or debate sort of an Uber version of the deliberative process privilege.
I understand that that's your theory, but if we disagree, if we look objectively at the nature of the act as the Supreme Court describes the inquiry in Bogan versus Scott Harris, if we say it is a constitutionally authorized and predicted activity of the Congress to investigate and write reports, is that the end of your case?
No, Your Honor, because there can be in any field of law an authorized act that is not privileged. That was the core of N. Ray Sealed case, was not everything that is authorized, not everything that is within Congressman Perry's official duties was privileged. And the question here is it privileged? And everything else in this case relies on that determination.
Wasn't this document supposed to be released publicly?
It was. It was put through declassification review. There was a lot of negotiation between the different branches. And the only reason the executive summary was all that was released was because the CIA and the White House said it's going to take 846 years to review the whole document. And Senator Feinstein and Sissy said, we'll just do the executive summary. We'll get the rest later.
And piggybacking Judge Pilgrim's earlier sentiments to you, I'm also concerned again about line drawing here. When you think about the original intent of the document, its oversight doesn't intend to have recommendations. It's a learning objective. And that's where it starts. But then later on, perhaps, legislation or something could come out of it. Do we go back to what the document started as and then how it finished, in the sense of it's just a final report? Don't worry about the legislation later. Don't worry about a later Congress which changes hands and there's different committee members now kind of recharacterizing the document?
I would phrase it a little bit differently, but yes, that is the core of our position, that if you look at the intention stated when they started writing the report, and then you look at what they did when they finished the final report, At that point, they had stated multiple times that this was to be given to the executive branch. It was not to be a secret Senate project that nobody saw. It was supposed to be declassified. They had actually tried to negotiate declassification. And that, as you might tell a first grader, there are no takebacks. The report
So
was
what if the Senate had voted and it voted 100-0 that we are not going to further publish this report in redacted form? All we're going to do is publish this redacted executive summary and full stop.
At what point?
They take that vote and that's what they decide.
No, when? After it's written? Or-
Yeah, after
okay.
it's written.
So if they were to vote to not disseminate anything else, I would say that that is still subject to the common law right of access, just like a judicial order to
They've
seal.
taken the legislative act of saying by vote, we're not going to disclose this any further. You're saying that that's not protected by the speech or debate clause?
Correct, because it's not deliberative. The vote was ex post facto. It was after the fact, and it does not change the fact of whether or not it's privileged. They can choose whether or not to claim a privilege, which is what they're doing now, but they cannot change whether or not it was privileged in the first place.
Do you agree that your action sounds in mandamus, whether you call it under the All Writs Act or 1651 or 1361?
It's definitely akin to mandamus. We did not make a mandamus claim for the very reason that mandamus arguably right now does not apply to Congress. And so
That's on the first page of your complaint. Not the first page.
we did not cite the Mandamus Act, I don't think.
Looking at
Did I?
J7, and you say that we have jurisdiction under 1331 and
Oh, correct.
1361. That's
Sorry, that
paragraph
was for the
1.
jurisdiction. Yes.
And then you cite the All Writs Act
Yeah.
in the introductory paragraph.
Yes, sir.
So you're seeking some sort of a writ.
We're seeking, yes, which is the only thing available. As the predecessor lawyer stated, this would be an unenforceable right.
Well, I'm trying to get to how, like, this is a clear and indisputable right to relief or a clear duty to act, when basically to get to the kernel of what you're alleging here is that Congress, the Senate committee, select committee published an executive summary, but they had a clear duty to publish a redacted full report, and that somehow that's such an abuse and so outside the bounds of their authority that that's subject to mandamus.
I understand.
How do we get there?
I understand the question. I apologize. So I think that it's not that they had a duty to publish it. I think that they had a duty to provide it upon request. Just like FOIA, you don't have an affirmative duty under FOIA to publish every government record, but you do have a duty to publish them when they are requested, if they are agency records and meeting all the other standards of FOIA. In this case, if it meets the public record status test and it's not covered by speech or debate, then yes,
I
they have a
think that
duty.
you're that's not really what I'm trying to get at. Whether somebody requested it or not, the crux of this is that somehow it's some sort of that the committee had a clear duty not just to disclose upon request a redacted executive summary. It had a clear duty to disclose a redacted full report. So like I'm just trying to understand like the delta between those two things, how that leads to grounds for a mandamus action.
I think that the question is one step removed from that. I think that the question, and this was the question that was raised by the appellees, that your argument was not raised below, is that, does the right apply, period? And once you decide whether or not speech or debate clause blanketly covers all committee reports, and that no committee reports, or this committee report was not a public record, if you get past those, then would be the time, honestly, in my opinion, to argue about whether or not, mandamus applied. But until then.
Well, that's kind of my point, is that even if you can kind of clear the hurdle that speech and debate clause doesn't apply, you still got to clear another jurisdictional hurdle, which is that somehow by not releasing a redacted full report, instead of, in addition to releasing a redacted executive summary, is sort of violation of some non-discretionary duty that can result in mandamus jurisdiction. And I just don't see how you get there.
I would respectfully say that the non-discretionary duty is the common law access to public records, that if.
On that, I'm sorry, I interrupted you in the middle of your sentence. The non-discretionary duty is the common law right of access to records.
Pardon me?
I interrupted.
Sorry. Sorry. That is the duty, that if there is a common law right of access to something, then not disclosing it is, or disclosing it is not a discretionary duty.
So on that, I mean, just as historically that right applied to the executive branch, but it has been supplanted by FOIA, why isn't the same true in the context of this case, where the Senate Intelligence Committee Rule 9.7 prohibits the disclosure of any confidential report except as specified? So it's basically creating a regime of authorization of disclosure that is more concrete, more specific, and is constitutionally grounded in the rules clause. No more common law right of access.
A couple of things, and I'm woefully over my time. So with your permission, I'm going to answer the question. The first thing is that FOIA is a statute, and that it takes a lot to overrule a common law right.
What's a statute?
FOIA.
Oh.
And that a rule by one house of Congress, in our opinion, does not overrule a well-established common law right. The second is that even the Senate rule talks about confidential records. We would say that even if that applies, this is not a confidential record. It was willingly disseminated to numerous recipients outside of Congress. That makes it not a confidential record.
Even if it's classified.
The classification is a stickier question, where we are arguing that you don't have to give us the classified parts, but you have to give us the unclassified parts. That's where the redactions come in. We don't want to fight over whether or not classified information overcomes the common law right.
Are you saying public record or not, though?
We're saying it is a public record.
Okay, because
it was generated by a body of the government for dissemination to another branch and to the public.
So not deliberative.
No, so not deliberative. Yes,
Okay.
Yes, Your Honor.
What's your authority for the notion that a rule is not sufficient to overcome the common law right of access? I think with respect to the judiciary, the federal rules of criminal procedure have been sufficient. So do you have any authority for the notion that a duly enacted committee rule would not be sufficient?
Your Honor, I don't off the top of my head, but that doesn't mean I haven't found one. This one, I can't think of it because I wasn't expecting that question.
So
Honestly,
is the promulgation of Senate Intelligence Rule 9.7 a legislative act?
the promulgation of the rule?
Yeah.
Yes.
So is the committee deciding when something is subject to the rule then a legislative act? when a document is subject to that protection of that rule, or
I would say yes, Your Honor,
then why isn't that the end of your case under the speech or debate clause?
because the committee decided that it wasn't. And later committees tried to change that.
The committee, if the committee decided that Rule 9.7 didn't apply, we wouldn't be here.
The committee,
That's the whole reason you don't have a redacted version of the report.
are you asking me are you saying because the committee later said that it didn't, that it applied? Is that what you're asking about? Not the first decision?
Well, all I'm saying is that you have requested it, they haven't given it to you, and they are citing Rule 9.7 as a reason why you're not getting it.
Okay, I understand. So they're citing it, they were for it before they were against it. Not to put too fine a point on it.
Well, that's fine. I change my mind all the time. The court can change its mind. There's nothing that says that the Senate can't change its mind.
The question,
If it's a legislative act, it's a legislative act. They might have taken one earlier and then they've taken a later one, but it's still a legislative act.
it's still a legal question as to whether or not it's privileged. If it's not privileged, if a legislative act is taken to declare something fundamentally not privileged that y'all would find is not privileged, but they vote to consider it privileged, do you have review? I would say yes, because they are violating the law. If it's not privileged, no amount of legislative acts can render it privileged.
I have just a detailed question. You bring claims both against the committee and against Senator Warner, and I take it the Larson-Dugan route only applies against an individual in his official capacity. Is that your understanding?
I would assume so. I did not get into the finer details of that. We named both for belt and suspenders to avoid arguing about whether or not it applied or the proper avenue for challenging this.
And you heard the previous argument. There was a question about whether the Larson-Dugan doctrine applies beyond where there's an officer acting in excess of statutory powers or an officer acting in excess of constitutional authority. And here your claim relies on a common law right. And do you have anything that you would add to what you heard from prior counsel about why you would disagree with the government on the limitations of the common law right of access?
Well, first of all, I think that it would be unwise to say that a government official could violate any common law they wanted and still claim sovereign immunity when it's a federal common law. I think that it is not a question this court can decide, honestly, right now, because it has already held that, or albeit in dicta, arguably, we would dispute that, but that the common law right of access applies to all three branches of government.
There is a more nuanced view that I think it was in
Washington legal.
maybe in Schilling, the House counsel was arguing that the statement that it applies to the legislative branch read in light of speech or debate immunity must be limited to Library of Congress, U.S. Capitol Police and the like, but not to the houses. And so that's a way of explaining the dicta, that it's correct dicta, but it's more limited than one might.
That's going to be your next case. That's the Leopold
Do
case.
you have a response? Because the next case, he's got that obstacle even on that reading, but for you, we could honor that dicta and still leave you without a claim.
I think that rather than looking at who it applies to, because as you can see, the government argues that it protects Library of Congress and the Capitol Police and everything else too. I think that it's a functional test. It's a case-by-case test where if the entity doing the thing that wants to be writing the report, writing the policy, whatever it is, if doing it in a non-legislative capacity, then, or if doing it in something that would not be privileged, it sort of conflates all the facts, it blends them all together, but it comes down to the fact that a committee writing a report for dissemination to the public is no different than the Capitol Police. It's no different than the Library of Congress issuing a policy that affects the public.
Well, the district court did say it was not a public record. You're urging us to say it is. But then if you do say it is, then you go to your balancing test. She says national security outweighs the public interest.
Right, and that was based on the idea that it was classified without any discussion of whether or not everything in it was classified. She said it was not a public record because of the speech or debate argument. So if you get past that, then all of a sudden, boom, it's a public record. That was their only stated reason for it not being a public record.
Do you have any instances of when any such like reports have ever been disseminated to the public?
Committee reports are disseminated all the time.
But I mean, this is a torture report. Lots of,
Well, I mean, there was the
national
executive
security issues.
It is well known. That's the entire purpose of mandatory declassification review. The Executive Order 13526 is about dissemination of things that are deemed, not entirely classified or declassifying them. FOIA, you get reports all the time. I get reports all the time that have been redacted. B1 is written next to the redactions. Or portion markings are written in the original document saying that a paragraph is you.
Can you cite us to any case where we have held, or any court has held, that you must declassify and produce a document in response to a request from the public?
You must produce it.
Produce a redacted. You must declassify and produce a redacted version of a classified document upon public request.
Well, that's all of FOIA, that all the B1 cases that say that. The entire rule of segregability say that, national security counselors, my firm versus CIA, there's half a dozen
No, I'm
cases
talking
that say
about
that.
under common law, public right of access, not FOIA.
Oh, not for Congress, but for the judiciary, certainly. Most of I personally have gotten things disseminated that were redacted, that were filed in camera because they were classified. And then I sued to get the document, just a case, Zoltek versus United States in the federal claims court a couple months ago. The judge ordered something to be released in redacted form, even though the government claimed it
What
was.
was the site?
I don't know the citations. It was
Or
called
the case name?
Zoltek, Zoltek.
But what was the basis for your entitlement to access to the document?
The public right of access, common law right of access to judicial records, to public records, which is the same right we're talking about here. And without any further ado, I would ask that I be given at least a couple minutes to respond to the arguments they make, but I would like to sit down and take some water. Thank you.
Morning, Mr. Caballero.
Morning, Your Honor. May it please the court, Thomas Caballero on behalf of the Senate appellees. The district court correctly held that the speech or debate clause bars this common law right of access suit against the Senate Committee on Intelligence and its chairman, which seeks the production of the committee's report on the CIA's detention and interrogation program. The Supreme Court has repeatedly stated multiple times that committee reports are covered within the legislative sphere and therefore protected by the absolute immunity of the speech or debate clause. This court itself, a few years ago, held that a common law right of access suit against the House Intelligence Committee seeking legislative oversight materials was barred by the speech or debate clause. A straightforward application.
But under your description, you would just say any committee report, we're done. Why do we even have these lawsuits? Do we have to at least look to the nature of the report?
No, the nature of a committee report is to inform the Senate to allow for its legislative deliberations. And I want to address the point that was brought up earlier. Committees do many things that have other effects, because most of what Congress does is in public. A committee hearing is to gather facts to inform the Senate, but it's also public. So it informs the public. It can have many other intents and effects. Be protected. The fact they may have these other situations, like informing the executive agencies about issues that arose that were looked at by the committee, doesn't remove it from the speech or debate privilege. That absolute immunity still attaches.
Question about sort of sequence of decision. The district court appeared to treat the speech or debate clause as a jurisdictional bar. But as I understand it, under our cases, if the claim itself is not predicated on the congressional action, but is seeking documents or information, then it's in the nature of a privilege, not in the nature of a jurisdictional.
I don't think that's correct here, Your Honor. This court has said that it's a jurisdictional question. Where it arises,
In the
it's
context of the suit being predicated on the legislative act.
right, but this is a suit predicated on legislative act. Where it's come up in an evidentiary situation has been, for instance, in the Brewster case or in the Gravel case, where there was a subpoena matter. And therefore, in a subpoena matter, the question is, does it fall within immunity and act like a privilege?
But this is really, and I mean, you can see this as a civil analog where the subpoena is the claim there, and here the claim in the non-criminal context is a common law right of access. I just wonder whether we have to decide sovereign immunity first before we can decide.
You can decide speech or debate first before sovereign immunity. You can decide them in any order. They're both jurisdictional. This is a suit.
Even if they're not jurisdictional, if I disagree with you that in this context, speech or debate is jurisdictional.
They're both threshold issues. I believe you could decide in either order as well. But again, this circuit has held speech or debate to be jurisdictional. This is a suit.
What are you referring to? I mean, it has held that, but in this,
Have to look and provide citations
I'm
later.
conceding that there are situations in which we've held that it's jurisdictional, but there are also situations in which we've held it's more akin to a testimonial privilege. And if the claim here is based on common law right of access, then and the assertion of speech or debate is to say, no, you can't have this. The claim is not.
Again,
The culpable conduct is the withholding of information. It's not something that Congress did it's not the hearing itself.
I think there's 2 points with that. This is a suit against members of Congress. The courts have said, if you sue a member of Congress and speech or debate applies, it's an absolute jurisdictional immunity.
Where do they say absolute immunity?
Yes, and this court has held that it's a
jurisdictional, but typically it's absolute immunity, meaning you don't balance, as opposed to absolute meaning it's jurisdictional.
It's both, but I believe this court has held, I would have to go, Your Honor, but this court has held that it's a jurisdictional protection against suit. And this is a suit. In Brewster, it was an absolute immunity that applied to a subpoena. That was also the case in the Minpeco case. That was also the case in Gravel v. United States. When it applies to a subpoena, you don't even have the ex ante question of a jurisdictional nature of a suit, where a plaintiff has to demonstrate jurisdiction. You have a subpoena that is being responded to. The speech or debate clause is not a deliberative privilege. It's a fundamental separation of powers protection for the legislative branch. And so it's more than just, for instance, you could never protect speeches on the floor of Congress if it was a privilege because it happened in public. Why did that not waive the privilege? It's because it's not a privilege. It's an immunity from suit. And what this case is a suit against committee and members of Congress.
But I mean, you're insisting ever more loudly, but not actually explaining why, because it's waivable. Subject matter jurisdiction typically isn't waivable. Why is this, I mean, why is this not more like the subpoena case, where the thing that the enforcer of the subpoena wants is information? Here, it's a civil claim for common law right of action. The thing that the person wants is some congressional information. The structure seems parallel to me, and I'm not sure that you've explained.
I would say two things in response to that. First is obviously this court has already held that it can affirm a dismissal on jurisdictional grounds on the speech or debate clause. That was Judicial Watch v. Schiff. So that's already the law of the circuit. I would say also that I wouldn't say that unlike when you're suing about a legislative act, you're just requesting information. The information being requested is legislative information. That's why it falls.
It may on the merits be entitled to speech or debate. I'm just trying to figure out a question about order of operation and the proper characterization of the effect of your speech or debate.
Understood. And I think,
Argument.
I apologize, Your Honor.
I'm a little surprised at the number of times that you've.
Sorry, I would say, I'm going to refer back just to the precedent and the Judicial Watch v. Schiff, where this court had a sovereign immunity and a speech or debate dismissal in front of it. And it found that it could reach speech or debate only, it didn't reach sovereign immunity, and affirmed on that ground alone.
It did refer to it as a threshold ground, and it cited Steel Co., which I think, as you also refer to that even if it's non-jurisdictional, it could be a threshold ground that one could reach without separately establishing jurisdiction. That's how I read that sentence in the opinion. And then the next sentence in which it actually refers to it as jurisdictional is really as support for the dismissal being non-merits and therefore without prejudice. And again, it's a little bit of a drive-by consideration of whether the speech or debate assertion there is jurisdictional or not, because it's not, neither of those sentences really pins down the question that I'm trying to get your enlightenment.
I understand, Your Honor, but I would say that as the Supreme Court has made clear post-Steel Co. that it doesn't have to be a pure jurisdictional question. You can decide threshold issues in any order. And I would say, therefore, this court, as the court did in Judicial Watch v. Schiff, can decide speech or debate before sovereign immunity, and either ground would be sufficient to uphold the decision below.
Let's go a little bit to the public record issue about this being deliberative or being a final report. And at what moment in time do we make that decision? Because there seems to be some consideration for post hoc rationalizations here that perhaps this could have been legislative, or perhaps now we decide that it's not just an oversight report where it's only not providing recommendations, et cetera.
Yes, I guess the question is, I don't believe there's ever been a statement by the committee that this report was anything other than a committee report to the Senate. The chair did make clear that she wanted it to be understood and used by the executive branch. The chair doesn't speak for the committee in all purposes. So I don't know if there's been
and public release.
Yes, but I don't know if there's been ever a committee decision. In fact, there's been a committee decision to only vote and seek for declassification of the executive summary findings and conclusions, which were declassified and were made public. So I don't think there's a question of now the committee's gone back on itself. I think the committee was always doing a committee report, and it never asked the executive branch to undo or declassify the underlying large report. It asked for the original. Therefore, I don't think it's a question.
But under your notion, again, any committee report is not subject to release.
Under the speech or debate clause, if it isn't public, of course, the large majority, well over, I assume 95, 98% of committee reports are public. So it's only the few reports like this intelligence report that aren't. And under the speech or debate clause, you couldn't sue a committee to force it to disgorge a report that wasn't made public in the normal course of the Senate's business. I believe the district court held it wasn't a public record because the public record doctrine, as delineated in Washington Legal Foundation, said that it covers public records were those records that memorialized or that essentially memorialized an act or order decision of legal significance. And the court below said, well, reports to the Senate are reports of a subsidiary body to its parent body for its consideration. And that wasn't a final act of legal significance, like passing legislation would be based on the report, and therefore didn't qualify under the doctrine for a public record. It also held it wasn't a public, that even if it was a public record, the balancing here would clearly cut in the government's secrecy favor, given the national security interests in the document. and given this circuit court's previous case discussing how the need to protect against national security risks overcomes common law right of access suits.
What if hypothetical, Senate committee votes that be in the public interest to disclose a redacted version of this report, but it's a lot of trouble to redact all the classified information. So we're just not going to do that. And the administration has said that they don't really want to do that. So we're just not going to do that. And then there's a lawsuit brought under this common law right of access that says, well, court, that's not, the relief we want is just the production of this, of a redacted version of this report. Assuming we believe that the common law right of access applies to the Senate, which I know you disagree with. How should we decide that case?
Well, I guess it would raise a strong argument that if the Senate committee thought it was a public record, but just was not choosing to submit for declassification, that it'd be hard to argue it wasn't considered a public record. But you would still have to apply the doctrine as this court's discussed in Washington Legal about, was this truly a document that was created and kept to memorialize some final act, decision, or order of legal significance? I would also say that in order to release this document, as the plaintiff has noted, it needs to go through a declassification review. And the executive branch is not a party here to be ordered to undergo a declassification review. And also there's no precedent that the judicial branch can order a congressional committee to engage such a request to the executive branch and how it handled its documents. So I think even in that instance, it's not clear that that would answer the question.
But the report said that it was not making any recommendation for legislation. And then I believe it was in April 2014, the committee voted for declassification and subsequent public release. So how do we square that?
The committee voted for declassification of the executive summary and finding and conclusions, not the whole report. And committee reports don't have to recommend legislative. They can report facts to the Senate, and it's up to the Senate to determine what to do with those facts. It doesn't have to have legislative recommendations to make it within the legislative sphere. It can find facts and present those facts to the Senate for its consideration, as was done here. Thank the court.
I think we have Mr. Pullum for the United States. Your rebuttal. Morning, Mr. Pullum.
Morning.
Move quicker. You might lose your spot.
Too slow. Good morning, and may it please the court. Thomas Pullum for the United States as amicus curiae. We outlined in our brief at least 3 independent reasons why this common law right of access claim fails. The first was sovereign immunity, and the second went to kind of more specific inquiries about this particular document. I'm happy to answer any questions about sovereign immunity. I'll be up here next. I just wanted to make sure that I had a chance to address the kind of specific arguments with respect to classified information. So happy to take your questions in any order.
On the sovereign immunity point, I have understood Larson-Dugan to be analog to Ex parte Young, that one can bring an officer suit to enforce a legal duty. And I understand that the Congress and the United States are taking the position that it does not apply to a common law right. So is it your position that if this were a case brought under Ex parte Young against a similarly situated state legislature, that even though that claim could proceed under a common law right of action, that cannot be done against the Congress?
So the doctrines do have certainly much in common. They serve different purposes. The purpose of an Ex parte Young suit is to ensure the supremacy of federal law. When we're looking at Larson-Dugan involving the sovereign immunity of the United States, the question is whether the official is acting as the sovereign, exercising federal sovereign authority. So for Ex parte Young, we do not ask whether the state official has state authority. The kind of state law question is put aside by Pennhurst. All that we ask is whether there is a violation of federal law and whether prospective relief is sought. So the natures of the inquiry are very different. So I think to answer your question directly, if the allegation was, if a suit was against a state actor and the argument was that the state actor violated state common law, that wouldn't come into the Ex parte Young analysis. The only relevant question is there a violation of federal law, which is supreme?
And so they could bring a claim under federal common law right of access?
To my knowledge, a court has not held that the federal common law right of access applies to state actors.
Well, I'm just following your logic about the supremacy of federal law and that's what Ex parte Young is about. And is Ex parte Young not also about ensuring the enforceability of federal law? Not just its supremacy, but its enforceability. It's not just a shield, it's a sword.
Yes, and not in this case. In the next case, the plaintiff cited two courts of appeals that have held that at least some aspects of federal common law are supreme for the Ex parte Young analysis. But we know that the common law can't come into play in the Larson-Dugan analysis because the Supreme Court said so. I think that's the square holding of Larson itself, which expressly rejected a third category based on the general law and said quite clearly that as long as an officer's actions don't conflict with the terms of his valid statutory authority, then they are the actions of the sovereign, whether or not they violate the general law. So I think for those reasons, we kind of have that question answered here. And to bring up a related question, again, before I get to the issues of the classified information, I believe Judge Pillard, you had asked a question, why would Larson draw this line? Why would it say statutory and constitutional claims and not common law claims? And I think the answer to that is that under Larson, the question is whether the officer acts for the sovereign so that his actions can be imputed to the sovereign. When we're trying to figure out when the official acts as the sovereign, we're looking at the officer's kind of authority and duties. Those are created by statute. That's how the federal government creates offices and gives duties and authorities to those offices.
Sort of a strange analysis because why would that imply that the claim has to be based on statute or the Constitution? Because just because you're bringing a common law claim doesn't mean that the officer is acting only under common law authority.
No, but the claim has to be that the officer is not acting on behalf of the sovereign. And the common law claim doesn't get at that question. The Supreme Court in Larson said, because we're asking this question, the plaintiff needs to clearly identify in their complaint the specific statute they're relying on. And that's to enable the court to determine whether the officer was acting outside of properly delegated authority. So just identifying a common law cause of action doesn't get at that.
Seems like that kind of begs the question, maybe I'm asking the same thing that Judge Pillard just did. But it's assuming then, it seems like the premise of your question is that the sovereign is not bound by common law. I mean, if the sovereign is bound by common law, then the official operating on behalf of the sovereign is also bound by common law, the same as they would be bound by a statute or bound by a provision of the Constitution. Am I missing something?
No, I just think the Supreme Court directly answered that question when it said if the actions of an officer do not conflict with the terms of his valid statutory authority, then they are actions of the sovereign, whether or not they are tortious under general law. And the court elsewhere said, we're asking whether the officer's actions are so illegal that they can be enjoined without implicating sovereign immunity. And it specifically said that, you know, these actions are so illegal only if they're not within the officer's statutory powers or they're constitutionally void.
So,
It was simply, go ahead.
so just to follow up, you know, I think in that same passage, the court says that there might not be immunity from damages, right, for a tortious act, but that's different than essentially kind of a mandamus type action where you're trying to force an official to act. So the court seemed to kind of create a distinction between an action like this, which is in the nature of mandamus or injunctive relief, compelling an official to do or not do something, versus an action for damages.
Well, I understood the relevance there to be kind of, you're asking whether the injunction against the officer would kind of run against the sovereign or just the officer himself because he was not acting, his actions could not be imputed to the sovereign. And when actions can be imputed to the sovereign, then the injunctive relief is barred just the same as damages, which is a separate question from whether there could be a court suit against the officer in his personal capacity. But when we're dealing with official capacity suits, and the officer his actions are imputed to the sovereign, then the relief runs against the sovereign and is barred. And I would like to turn to some of the arguments specifically about classified information here. First, on the public records inquiry, this court has recognized that there is just no right of access to information that's kept secret for important policy reasons. And we've cited a long tradition of recognizing the important policy reasons that call for the protection of national security information. I don't think there's any meaningful sense of the word public in which classified documents could be considered public records. The executive branch has constitutional authority not only to control access, to kind of designate this information and control access, but decide who has access to it. And providing...
But his claim is that we don't want any of the classified information. We just want a redacted version of the full report.
So just as an initial matter, that's not what was requested in his complaint. He asked for the report because it is a public record and said that the public interest, said there was a public interest in disclosure of the full report. And he asked for the report to be provided to him. So just as an initial...
Is that the posture that the district court decided the case, or did the plaintiff ever refine? It seems like on appeal, the plaintiff has refined his argument to say, no, we're really only asking for it to go through the declassification process. At least that's what I took to be the nature of the argument at this stage.
Yeah, so even if that's true, I'm not aware of any authority that providing that courts have kind of a common law authority to require this. We can look at the court's most recent case involving a common law claim for a classified document, and there it was actually a judicial record. And the court said simply in one sentence that the law of this circuit is that the need to protect classified information outweighs any public interest. The court did not say, well, can we break, there it was a video, can we break this video down, see if there are any unclassified frames of the video, and release that? The court treated the record as a whole, recognized that it was classified, and said that's the end of the story. And so,
Just so that I'm clear,
What case did you citing to?
I'm sorry, that's DIAB,
Okay.
DHIAB.
just so that I'm clear, is there a waiver or forfeiture issue here in that the plaintiff never said in the district court, all we want is redacted version?
So I'm not sufficiently familiar with all of the
That's fine.
documents.
If you can't answer the question.
I don't know that that's not the way the district court, I didn't read the district court's opinion to treat it that way. District court, I think, similarly understood that Mr. Musgrave was looking for the whole document. And just on this notion of segregability that Musgrave relies on, I mean, that is a concept under FOIA that's required by statute. So what I think, in effect, Mr. Musgrave is asking is for the court to import the FOIA concepts he likes, like segregability, ignore the ones he doesn't, like the exclusion of Congress from the scope of FOIA, and kind of select this mix that the court can impose through its limited common lawmaking powers. That sounds more like a legislative authority than a judicial authority. And I don't know of any cases that have said that a court can require the executive branch to undertake this review, especially when the executive branch isn't even a party to the litigation. I mean, because FOIA kind of takes care of this in for executive branch documents, this is only going to come up when someone requests classified information from the legislative branch. So where we're going to end up is a court saying, well, legislative branch, you have to disclose this, you have to request declassification, and executive branch, you have to participate. And that seems like a fairly aggressive posture to take in this position. And one last point, if I could, is just to point to the relevance of this court's ACLU versus CIA case, which involved a FOIA request for this very same document. And this court held that the committee had clearly expressed its intent to control the document and make decisions about public release, and that overriding that intent would raise separation of powers concerns. And I think if those are sufficient to control the outcome in a FOIA case, they apply necessarily in a heightened manner when we're relying on common lawmaking.
I hate to keep you up longer, but just circling back to some of the questions about the structure of the inquiry and the jurisdictional questions. And I understand that you do not think it applies, but you also argue, I think, in your brief that if the Larson-Dugan exception is triggered by the common law right of access, then the question of jurisdiction merges with the question on the merits. And maybe it's just not parallel. You know, I've been thinking about Larson-Dugan as the less familiar cousin of the Ex parte Young claim. And in the Verizon case, the Supreme Court said we don't merge with the merits the question whether there's jurisdiction under Ex parte Young. And I wonder whether, you know, what you think about that, the precedents that say you have to look at the merits to figure out whether the Larson-Dugan exception to sovereign immunity is available.
Right. So we took that aspect of Washington Legal Foundation as, I mean, that is the precedent set in that case. We accepted that and argued within that. We haven't made any kind of other argument here. I kind of don't want to get ahead of what the SG might decide if this were kind of, you know, free to go wherever we could go. But I will note that Larson itself, in footnote 10, said jurisdiction in this type of case does rest on the decision on the merits, because the court was asking whether it was just an error of law that was claimed or outside the scope of authority. And for that reason, as I mentioned before, that's why it's incumbent on the plaintiff to clearly identify the statute on which the claim is based. So I do think, at least if we're looking at larceny, there is some reason to believe that Washington Legal Foundation might have been correct in that regard. And it's similar to how this court approaches mandamus, where the jurisdiction and merits merge. These are kind of not totally dissimilar ideas. So that may provide some too.
Well, that's, I guess, why I've been kind of asking all these questions about like, what claim is this? I think here, Mr. Musgrave explicitly invoked 1361. Seems to be a mandamus claim. And as you say, they're kind of, whether we have mandamus jurisdiction merges with the merits to the extent that we look at whether there's, clear right to relief and clear duty to act and that sort of thing. And so given that, why isn't that really the kind of cleanest and easiest way to decide this case?
I think that's certainly an available option. We, as I, in one of the briefs, I apologize which one, we have not argued that mandamus relief is not available against the legislative branch. I know there is case law to that effect out there. So that's just not an argument we raised.
But even if it is, if he doesn't meet the mandamus standard, we don't have jurisdiction.
That's right. So that's just another jurisdictional ground. I think all of this, because of the merging and the presence of mandamus, basically all of this is jurisdictional. And so the court has kind of several different off-ramps. It could go through Larson-Dugan. It can go through the scope of the common law, the particular balancing, the mandamus. I think all of these are generally available.
And is it your view that if 1361 were unavailable, as the circuits to have addressed it have held, again, in an action against legislative actors, then we still, in recognizing a jurisdiction under 1331, it would still be in the nature of an affirmative injunctive request that would be subject to those same inquiries that Judge Wilkins mentions, the clear right to relief, clear duty to act, no adequate alternative.
I think that's right. This court has recognized in the past that when you're seeking this type of injunction, it is akin to mandamus, and so the standard should be similar.
And you're thinking of?
Oh, goodness, I think there's a footnote in Shawn.
Yeah,
I believe.
I didn't mean to. Put you on the spot.
Yeah, I think it's in Swan. There's a footnote that says, "We note that a request for an injunction based on general federal question statute is essentially a request for writ of mandamus." So same standard there.
You've been very helpful. Thank you. Other questions?
Thank you very much.
Now we'll hear from Mr. McClanahan on his rebuttal.
All right. So I'm just going to respond to some of the things that the opposing counsel have made. I will say one thing in clarification. When I mentioned the Zoltek case, that was not classified information, but it was information that the government asserted was protected for national security reasons. That was case number 96-166 in the federal claims docket 573. As far as a classified information case, there was a declaration and a motion that were classified and were ordered to be released on the public record by Judge Howell in National Security Counselors versus CIA, case number 11443, in motion by a minute order on February 15th, 2013. That was one of my cases. And in fact, it was my declaration that she ordered to be released. just going to say to one of the most recent points that the government council made, that at the district level, we definitely mentioned segregability. We definitely mentioned redactions. And I'll quote from our reply for partial summary judgment that Musgrave does not maintain that the secrecy of national security information, in other words, the classification of information, is outweighed by a countervailing public interest. He simply argues that there is at least 500 pages worth of information in the report, which is not classified, if not much more. And then it'll go on to talk about how no circuit has held that the presence of classified information in a document means that the entire document can be withheld, going back to 1977 in Weissman versus CIA. To one of Judge Wilkins' questions, I think the best analog here to his question about what would happen if the Senate then ordered something to be not released is the hypo that what happens if there is a published report and it is printed by the GPO and the GPO runs out and Congress then votes not to release it anymore? Can you sue for that for a copy of that report, saying that it was intended to be disseminated and it was disseminated? We would say yes. And so that is a variation of what
Yes,
happened
why?
here. Yes, what?
Yes, but why?
Because it was not, the privilege was deemed not to apply. It was ordered to be released. They can't take it back later when it politically changes hands. And as far as
What's the precedent for the no take back rule?
this is a case of first impression as far as I've found. So the precedent is playground rules. I mean, it's one of those things that it's logic. It's the way that privilege works. If a client asserts privilege or does not, if a client does not waive a privilege in an attorney-client matter, they can't later claim it's privileged. Privilege is or it isn't. When you decide that something is not privileged, you can't change your mind. And that's
Usually the case after it's cat's out of the bag and it's been disclosed, but I don't know that I've seen a decision that said that if there's a privilege review and something is deemed not privileged and before the document's actually disclosed, they, do another review and they claim the document is privileged. Well, they can't do that because they can't change their mind.
we would argue that it was disclosed when it was sent to all the executive branch agencies with no restrictions on its dissemination. And
Privilege law, you have Rule 502, which kind of allows a clawback provision that if it's inadvertently disclosed, you claw it back.
this wasn't inadvertently disclosed.
There are take backs.
If it was inadvertent. I'll grant you that. Kindergarten does not directly apply to federal law, but yeah, I'll grant that. And in closing, I would simply say that the Supreme Court has held twice in McMillan and Hutchinson that this is the way things should be. In McMillan, doubtless also a published report may, without losing speech or debate clause protection, be distributed to and used for legislative purposes by members of Congress, congressional committees, and institutional and individual legislative functionaries, not the executive branch. And in Hutchinson, the transmittal of such information by individual members in order to inform the public or other members is not a part of the legislative function or the deliberations that make up the legislative process. Put those two together and you have that dissemination outside of Congress and the stated desire to get it declassified for public release means it's not privileged. And that's where the question ends, as far as we're concerned. Thank you very much. And if you have no further questions.
Thank you. The case is submitted.
Case number 22-5304. Jason Leopold, appellant, versus J. Thomas Manger, Chief, United States Capitol Police, and Ronald Gregory, Acting Inspector General of the United States Capitol Police. Mr. Light for the appellants, Mr. Poem for the appellees.
Morning, Mr. Light, you may proceed when you're ready.
Good morning. Thank you, and may it please the court. This is Jeffrey Light on behalf of plaintiff appellant Jason Leopold. Since there are several issues in this case, I wanted to begin by summarizing what it is that we're asking the court to do. For the subset of Capitol Police directives that do not contain security information, we're asking the court to hold that under the first step of the common law test, the directives are public records. And at the second step, to remand for the district court to decide whether portions of the directive can be segregated and released. For the documents that do have security information, and this includes some of the directives and some of the IG material, we're asking that this court to hold that there is a segregability requirement in Section 1979 and remand for the defendants to explain whether there is any non-security information that can be segregated and released. We're not asking the court to determine whether the district court or the Capitol Police erred in their judgment in terms of what's security information or not. We're asking simply for the court to resolve a question of statutory interpretation for 1979. That is, whether it applies to documents or information. And finally, as to the IG reports, we're requesting a reversal and in order that the government comply with the IG Act public posting requirement. Again, the court only needs to resolve the statutory question as to whether the public posting requirement applies to the Capitol Police. On remand, the Capitol Police would be free to assert Section 1979 or any other privileges that they may have to portions of the IG report. And to begin with, I want to start with the issue of whether the directives are public records. And we think that there's a pretty straightforward definition in WLF2, which is that you look at whether the statements were created to memorialize a decision or statement that has legal significance. And the Capitol Police directives meet that test here. One of the ways in which the term legal significance can apply is that it's binding on a party. And here it's binding, these directives are binding on the Capitol Police and its employees. The government contends that legal significance only counts if it's binding on members of the public. But there's no authority and no suggestion in WLF2 that that's the case. And in fact, it cuts against the wording in WLF2 that the term legal significance should be broadly construed. The government also in the district court rely on their argument that the directives are preliminary. But in WLF2, this court never really explained where it got the word preliminary from or why it was incorporating that into its decision. And so I think it's worth taking a moment to ask why preliminary materials are not covered by the common law right of access. And in a whole variety of areas of law, we find that preliminary disclosure of preliminary materials tends to inhibit candid discussion, reveal an individual's raw thoughts, might often be incorrect. And this stands in contrast to official final policies. The California Supreme Court and some subsequent cases there actually looked at WLF2 and its use of the phrase preliminary material and elaborated on that to a great extent and looked at factors such as whether the material is tentative or interlocutory, whether it reflects the raw and immature thoughts of the authors, and none of those indicia of preliminarity apply here.
Mr. Light,
Yes.
Go ahead.
if we were to agree with you that the written directives are public record, then we would proceed to the balancing test to determine whether the district court abused its discretion in concluding that the balance of interest weighed against disclosure. And I think you've argued that at least the district court should have had some kind of further information, Vaughn Index style, about the nature of these directives. Is that uncharted waters? Have we ever, in this kind of a context, made that kind of demand?
But in WLF1, the court remanded for a Vaughn-like index to be prepared. But I think it's just a sort of basic premise of the adversarial process that both parties have access to the information that's needed to mount an effective argument, and that the district court have the information before it to make a reasoned decision, and then that the appellate court has a record basis on which to determine whether to affirm. So there are a lot of FOIA cases which discuss this, and it applies here. This obviously isn't a FOIA case, but FOIA occupies a universe where there's a great imbalance between the information that the parties have, and the purpose of the Vaughn Index is to remedy that to some extent so that the adversarial system can play out. The same is true here.
I have another, just going back to the very beginning. The complaint in this case invoked only the mandamus jurisdiction, 1361. And if we were to agree with the other circuits that have held that's not a viable basis for subject matter jurisdiction in lawsuits against officials in the legislative branch, is that alone a reason that we would have to dismiss your claim, your case?
No, I think that it's largely an academic matter whether jurisdiction is proper under the Mandamus Act or the general federal jurisdiction question. And the reason I say that is because when in Swan v. Clinton, the general federal jurisdiction statute was said to have been essentially properly relied upon, but that it's the equivalent of an injunction. An injunction under the general federal jurisdiction statute is roughly the equivalent of seeking a writ of mandamus. And since this case was dismissed, of course, without prejudice, the effect of doing that would simply be for plaintiff to refile the exact same case, adding in the general federal question statute as a reference. And I don't think that would be in the interest of judicial efficiency to proceed.
But it's not just a matter of pleading, it's a matter of what do you have to show to properly invoke subject matter jurisdiction. You have to show a clear and indisputable right to relief, no other remedy available, and clear duty to act. And then if you meet all three of those, you still got to show that, equitable, under the court's equitable discretion, it should order the writ. So how are we in the realm of clear and indisputable right to relief or clear duty to act?
So I agree with you that those mandamus standards are applicable here. And there's no question that there's no alternative form of relief here, number one. And I guess the real nub of the question then is, number one, is there a right to relief, which goes to the merits? And number two, is this right so clear and indisputable? And on that prong, I think that it is important to look at the specific relief that we're asking for here, because I would agree that if this was merely an error of judgment on the part of the Capitol Police in determining what to release and what not to release, that probably would not meet the mandamus test. But what we have here is a question of statutory interpretation for 1979. And we also have for the common law issue, a question of law as to what is even required. Once this court sets forth what the proper standard is, it may be that there's no dispute at all. In fact, that the parties agree as to what material is properly released and not. But since the Capitol Police haven't applied the proper standard in the first place, that is this.
Well, let's suppose the Capitol Police referred the matter to, their general counsel, others, and they issued a written finding that, we've balanced everything under all of the relevant precedent, and they cite all of the cases on common law right of access. And we believe that under that balance, none of these documents should be disclosed. What do we do with that? What happens under those facts?
Well, we're not at that stage yet, and I think it's important that we not get too far.
It's a hypothetical question.
Okay.
I'm just trying to understand the ramifications of your argument here.
I understand. It's going to depend a lot on the context in which that comes up, because if the police make a decision where they take into account segregability and do all the balancing and whatnot and come up with a decision, and that error that we see is just one of judgment or discretion, then there's nothing we do at that point. We lose at that point.
I thought I just heard you a couple of minutes ago say that the claim is under 1979. I thought that was an obstacle to your case because it supplants the common law right of access as to documents that are designated as security information.
Not sure if maybe if I misspoke on it. Our claim is brought under the Mandamus Act, the General Common Law right of access, and the General Federal Question Jurisdiction. But 2 USC 1979, the purpose of it here is that that is the grounds for withholding. And both the district court and the Capitol Police made an error of law in interpreting it. And so under this court's doctrine of non-statutory judicial review, we have asked for review of that agency decision. Obviously,
you're saying I'm sorry, go ahead. Obviously,
in most cases, the APA applies. And so the non-statutory judicial review is maybe not as familiar a doctrine, but it has largely the same elements as a writ of mandamus.
But when you say that the Capitol Police erred in applying 1979, you mean that they wrongly designated documents as security information?
Sort of. What I'm arguing is that they interpreted the statute to mean documents can be withheld and they don't need to be segregated, even though the statute specifically says information. And because of that incorrect interpretation of the statute, they never decided in the first instance whether there is any information that can be released.
Is that claim really in your complaint? I mean, as I understand it, that would be a claim for failure, a claim arising under or under 1331, but for failure to appropriately apply 1979, not a claim for right of access. Is that too technical in your view?
Well, the Capitol Police hadn't invoked 1979 at the time the case was filed. That's something that happened at the summary judgment stage, or at the motion to dismiss stage. So that was the first opportunity we had to explain why we thought that we had a right to challenge the decision that they made.
And as I understand the way the Congress is using it is, or the Capitol Police is using it, is not that you then get to inquire how they're administering that regime, but that is the substitute regime. And therefore it supplants the common law right of access wholesale. It doesn't infuse it or inform it, it supplants it. And if that's right, then, where it applies, it preempts. And the Congress itself gets to decide what counts as security information according to its specified procedures.
I think that's right to an extent, which is that where the statute applies, that is where there is actually security information, it preempts or supplants the common law. But the question in the first instance, right, did Congress say that security information can be withheld, or that non-security information can be withheld simply because it's in a document that contains security information? Congress didn't say that.
But isn't the Capitol Police position, and I understand that you object that it's a blunderbuss position, but isn't their position that these directives are security information?
They are saying that they are security information and that they contain sensitive security information. They've never said that every single word in these documents cannot be released because it's security information. In fact, we have put in the record an example of one or two that had been publicly released. And so the court can see, there are these different sections laid out. Perhaps some of the sections go into some issues that will involve security information. Some of them are more preliminary. The balancing of those different sections is something for the court to decide at step 2 of the common law right of access. But as far as
the question is it? If 1979 supplants the common right of action, and then the question of what is the appropriate granularity or what's the appropriate unit size of what is security information, is it really for the court to say, or is that something that is for the U.S. Capitol Police to say under its procedures, under its regime?
Well, look, I think if the Capitol Police said we went and we reviewed line by line every directive that we said contains security information, and we determined that all of it is security information, then I think that's correct. There's nothing left for the court to do. But that's never happened, right? What we're asking for here as a remedy is that the Capitol Police be ordered to, and maybe it doesn't have to be line by line, maybe it can be section by section, but that they review and determine whether there's anything they think is non-security information that can be released. And in fact, that's something that they've done in the past when Congress has wanted to release information about January 6th. The Capitol Police then went back to the board and sort of discussed whether this can be released. So this is, very much in their ability to do. If they had issued a statement like you see in a typical FOIA case that says, we've reviewed and we've determined that no segregable information exists, and here's why, then I agree, that would be the end of it. That just hasn't happened here.
Can you cite to any authority for a court in a common law right of access case to order the official to basically enforce a segregability requirement?
So I think particularly instructive on this is this court's decision last year in Ray LA Times, which is 28 F 4th 292. Because in that case, this court found that the district court had erred by refusing to consider redaction as an alternative to complete withholding under the common law right of access. And prior to that, in 2021, this court issued a decision, case called CNN versus FBI. And in that case, which involved the common law right of access, the district court had applied the Hubbard factors and had done that in a way that it applied them to all of the documents that were at issue in litigation, or alternatively documents as a whole. And this court reversed and remanded and said, no, you need to look at the precise portions that are redacted versus not redacted and make a determination as to those granular pieces of information. What is the public's right of interest? What are the secrecy needs on that level of granularity?
Let me ask you about your efforts to get the OIG reports under 1909. You take this dynamic incorporation of the Inspector General Act as your starting point, but even if we agree with you on that, does 404E1C mandate the same disclosure? Because it has this caveat that's nothing in this subsection shall be construed as authorizing an inspector general to publicly disclose information otherwise prohibited from disclosure by law. And as we've been talking about 1979 as implemented by Order 1716, according to the Capitol Police, prohibits the disclosure of all OIG information. So the caveat in the dynamically incorporated portion of the Inspector General Act seems to give up the ground.
So I agree in part. There is that provision that notwithstanding other provisions of law, which I think would properly incorporate Section 1979. That is, if portions of the IG reports contain security information, then the Capitol Police would be able to withhold those portions of them. But the order that was issued never said that. And in fact, when plaintiffs argued in our brief, we tried to explain why we thought that there were portions of the IG report that were not security information. The defendant didn't disagree with that and wrote in their motion that the order allows for the withholding of not just security information, but all IG information. So the question then is this order on par with the law as understood and the Inspector General Act? And I think it's important to recognize here that under 1979, there is a provision for the Capitol Police to implement regulations. And there's a process they need to go through that to promulgate formal regulations, which they did not do in this case.
So you're arguing that the otherwise prohibited from disclosure by law, that the order 17.16 is not law within the meaning of that caveat?
That's correct. If it were otherwise, then every agency out there could simply say, we direct that the Inspector General not publish their reports, which would defeat the entire purpose of this amendment to the Inspector General report. In fact, it does sort of seem potentially the case that that's what happened here, that in response to the Congress amending the Inspector General Act, that shortly thereafter, this order came out that said, no, the public posting requirement will not be honored.
Is that argument in your brief?
I made it to the district court. I did not reiterate it to this court. I don't think it's an essential part of our position. I just thought it would add some context.
Right.
I just also wanted to, on the Larson-Dugan question, I just had one thing I wanted to add, if there aren't any other questions, if that's all right.
Take a moment. I think we've taken you far over your time and we're ready
Okay.
to hear from the government. But if you have one point you wanted to make about Larson Dugan, we'll hear it.
Just this, that the questions earlier relating to from the previous case where counsel had referred to the two possibilities, statutory authority versus unconstitutional act. To be very concise, what the Supreme Court was doing with that language was distinguishing between ultra vires acts and merely tortious conduct. And the way that we've set up this case, we are alleging that there is ultra vires conduct in the failure to follow the clear language of the statute, which only gives authority to withhold under 1979 things that are security information, and under the common law, which under WLF2, it merges with the merits.
Thank you. We'll give you the rebuttal that you've requested.
Thank you.
We'll hear now again from Mr. Pullum.
All right. Morning again. Again, I'm happy to answer any questions on the arguments made in the brief, but a lot of the colloquy I just heard focused on Section 1979, so I thought I'd start there to just underscore how this statute works. 1979 is a limitation on the board's authority to release certain information. It does not provide anyone with a right of access. It does not require the board to release anything at all. And it certainly does not have a segregability requirement, such as is present in FOIA. So to the extent that the plaintiff is trying to bring some kind of non-statutory review claim, which, as I think the court noted, was not in the complaint, this clearly would not meet the requirements for non-statutory review, because there's been no kind of clear and palpable transgression of a statutory command here. So I think really that is just not something the court needs to worry about, because it does not fit within that category, even if it were properly pled here.
In the record, Mr. Pullum, there's a reference to the designation of information as security information. Oh, I'm sorry, on the non-security information directives. It's done by who? Who actually makes these determinations? There's a reference to some team. You know what I'm referring to?
Yes, so I think
review team. I wonder who they are, and how do we know that they legitimately have unreviewable discretion to make these determinations?
my understanding is that these were kind of government officials within the Capitol Police organization. I'm not sure exactly where or what their precise titles were, but they were within the Capitol Police. And I think as Your Honor indicated, our argument here is that the way 1979 is structured, it gives the decision to the Capitol Police organization to make these decisions, and information can be released only if the board makes a specific determination, and that determination certainly wasn't made here. There's no allegation that the board determined that certain information could be released and that information was not provided. But again, this statute just is not set up as an equivalent to FOIA or an equivalent to any kind of access providing statute. So I think any reliance on 1979 is kind of misplaced here. A couple of other points I'd like to hit. With respect to redaction, I think there was a question on whether a court has ever required a coordinate branch to redact its documents under the common law right of action. I'm familiar with one of the cases that plaintiff's counsel cited, the CNN versus FBI case, and that involved judicial records. And I think that the Supreme Court recognized in Nixon, when it first talked about the common law right of access, it said that courts have supervisory authority with respect to their records. This court made a similar point in Leopold, where it said that kind of decisions about access and providing public access to judicial records is the responsibility of the judicial branch. The judicial branch does not have supervisory authority over the record-keeping practices of coordinate branches, nor is it responsible for determining questions of access and transparency. Those questions are up to the other branch, here, the legislative branch.
And there's no statutory authority that's been pointed to that would wholesale establish an alternative regime or a supplanting regime.
That's right. I mean, the only kind of wholesale regime is FOIA, which deliberately excludes Congress from its scope.
I guess the federal rule, we have the Dow case where the criminal rule displaces the common law.
That's right.
Right of access.
That's right.
But to the extent that Mr. Light is arguing that the documents have been wrongly designated as security information, why isn't that part of his claim? It's sort of saying that the extent that the Capitol Police are relying on 1979, they're exceeding its bounds. They're basically acting ultra vires under it.
Yeah, so I think 2 points here. One, I don't think that statute could provide, as I said before, I don't think that statute could provide a kind of grounding for an ultra vires analysis, because there's no restriction in that statute, clear restriction that's been violated. This sounds very much like an error in the application of the statute, which does not amount to ultra vires. And with respect to the alleged error, what I heard counsel to say this morning was that he doesn't disagree with designations of like identification of security information. What he disagrees with is the level of granularity so that it can't be done on a document basis. In other words, he says if there is something that counts as security information in a document, and there is other information that on its own would not be security information, then you can't say that whole document is security information.
And he actually has pretty robust authority for the notion that across the US code that there's a different treatment of, especially in disclosure statutes, of documents versus information. And that when Congress uses information, it does typically mean information within a larger unit. So I think that's his argument.
Yeah, but again, this depends on, I think largely this is driven by comparisons to FOIA, which is a statute that provides a right of public access, imposes on the agency a burden to demonstrate that information falls within a particular exemption, and then has a segregability requirement saying, okay, even if you satisfy your burden under exemptions, you still have to segregate and release the rest. Section 1979 doesn't have any of those features. No right of access, no segregability, and it's not making any kind of distinction between information and records as a whole. And I think
even if we think about, as I was suggesting to Mr. Light, if we think about 1979 as a different regime that supplants the common law right of access, by its terms, it is limited to security information. It just is. It only speaks to it. It doesn't speak more generally to information within the custody of the Capitol Police, it says, notwithstanding other provision, this is after the definitions, the first substantive provision is any security information in the possession of the Capitol Police may be released only if the Capitol Police Board determines that the release will not compromise security. And so if you think of the sort of footprint of 1979 as limited to security information, then it doesn't displace the common law right of access with respect to information that is not security information. So it is the statute's own edge that allows Mr. Light's claim to go forward on that argument.
I mean, I'm not sure that's the best way to look at that here, because it is because of the many different ways it displaces the common law. One, by providing a default of secrecy. One, by setting.
As to security information, the only information it addresses.
But it doesn't say what the kind of level of granularity is. And there are some regimes, for example, classified information. You can have a 10-page document, and if there's one paragraph that's classified, that document is classified for purposes of the proper executive order. Now, FOIA comes in with a segregability requirement that is separate, but at least, so I'm saying there are systems where we treat documents holistically. And I think that's what security information is doing
And
here.
your best textual argument in response to Mr. Light's argument only using the term information. And although it gives the Capitol Police Board authority to promulgate regulations, we don't have a regulation that interprets this term.
That's right. But I think the statute also displaces a court from making the determination. I mean, this statute is kind of suffused with deference and discretion to the Capitol Police to decide what is sensitive, which is an inherently kind of discretionary and judgment-laden call.
So do you go so far as to say that the determination of security information is not ever subject to review?
I think that's right. There's no provision of judicial review in Section 1979. The Capitol Police and its board are not agencies under the APA, so you can't seek judicial review that way. Council has said, well, we can get non-statutory review, and I think I explained why we don't think that applies here, because there's nothing in this, no command in this statute that has been clearly disregarded. I mean, this court's test for non-statutory review is really quite strenuous, quite rigorous. It has to be kind of no authority whatsoever, not a garden variety claim of error, and jurisdictional or nearly so. Court has recent cases, Federal Express, the Changji case. That's a very, very high bar, and I don't think that there's anything in this statute that could ground ultra vires review. Happy to answer any other questions about sovereign immunity that we didn't get to, or the scope of the common law right of access that we believe does not extend to documents in the legislative branch. Otherwise, happy to rest on our brief.
Thank you.
Thank you.
Mr. Light, we'll hear from you briefly on rebuttal.
Thank you, Your Honor. There are a lot of moving pieces here, but the issue of what I've been calling segregability seems to be at the heart of a lot of it. And so I wanted to explain just a little bit more what I mean by that. In terms of the common law, when a document is a public record, then a presumptive right of access attaches to it, at which point the government can overcome that by showing the need for secrecy, and a balancing takes place. But the default is that public records in this country are to be disclosed. And so that's the starting point, right? 1979 then comes along and is in derogation of that common law right. And so to the extent it applies, it will displace the common law. However, we need to be careful to read it exactly as Congress wrote it. And this is not an instance of, field preemption or something like that, where there's a statute that completely displaces the entire common law regime. This is just a single non-disclosure statute. It tells the court when things that would otherwise be disclosable should not be disclosed. But if the statute doesn't apply and the government can't meet its burden on the second part of the test, then it needed to be disclosed.
But to the extent that you prevail, you have to still show us that there's kind of a clear and indisputable right to relief. I mean, what we've said before, last term in Illinois v. Ferrero, the Equal Rights Amendment case, we said, even if the plaintiff has a legal argument with some force, that doesn't get you over the mandamus threshold. It's got to be an argument that is indisputable. Do you agree that that's the standard you have to meet?
Yes, but the standard is with respect to Section 1979, the standard is once the statute is construed, the right needs to be clear and irrefutable. So our argument here is that the court should construe the statute and remand for the district court to determine if at that point it is clear and indisputable. As for the common law issue, whatever the government may be wishing to do later, at this stage, we're bound by you're bound by WLF2, which says the ultra vires question merges with the merits of the common law right of access. And so that is the equivalent test to mandamus, the clear and indisputable right of access. If it's ultra vires and you meet all the other tests of mandamus, you're entitled to relief.
Mandamus says it's non-ministerial.
That's right.
Is that the same thing as ultra vires? Doesn't seem like.
Those are two separate things, right? But the disclosure of a document is a ministerial act. We're not asking for the court to order the police to determine what a reasonable rate is for a freight carrier, right? We're asking the ministerial act of give us this document.
Thank you.
Okay.
Thank you. The case is submitted.
Thank you.
14,